No need to postpone it. Then.
Lordship, I'm not in this case, Your Lordship. Lordship, I pray that the matter may be taken up after some time, Your Lordship.
Very pleased. My lord, this PIL is agitating, my lord, a serious issue, my lord. My lord, what happened, my lord? There is a continuous cause of action going on in the district of Dima Hasao. On Assam Mala road project has been initiated in the Dima Hasao district in the year 2020. Now, my lord, the Land Acquisition Act 2013, that was applicable also in the district of Dima Hasao. Now, your lordship will see, my lord, what happened. My lord, these affected villagers, they have a legal right, at least to have their land been taken up, then the authority ought to have at least surveyed their land or compensation. Something has to be done, my lord. But district council, my lord, is totally, my lord, silent on this. Now, what happened? PWD, RD, my lord, Roads Department, my lord. They are the implementing authority, my lord. Now they with the contractor, my lord, with effect from December 2023. I have annexed everything, my lord, even the FIR also. Now they have rampantly, my lord, activated to art cutting. And they even in the Dihangi area, my lord, I have annexed the photograph also. Your lordship will see page 217 also, Dihangi area. They have, my lord, art cutting started in the some of the affected villagers, my lord. Page 217, my lord, is just a photograph one. Now, page 219, your lordship will see, this is also the some of the affected, these private lands, my lord. Although, my lord, state have a right to, my lord, acquire land, there is nothing, my lord, that we can, my lord, stop them. But there is no absolute immunity, my lord, that they will not adhere to any provision of law or any act. Now, at that stand, my lord, we have to approach this court, my lord. Because if their lands are taken up, but at least, my lord, not in a way that they will be deprived of everything. So, your lordship, we have also filed various complaints. Please, 190, your lordship will see, the one complaint was lodged also to the superintendent of police, my lord, at page 190. FIR and complaint against Revenue Secretary, Autonomous Council, and Mr. So-and-so for art cutting without payment of so-and-so defying order of High Court. Now, on this, my lord, the state authorities, my lord, they are not trying to protect the anything.
These PIL is having the same course of action with the PIL which my learned friend had earlier filed. That is PIL 66 of
No,
2023.
that I've stated.
Lordship. Because if the Lordship states the synopsis of the PIL or both the PIL, it's the same.
No.
Same cause of action, same. I have the copy of both the PIL, Lordship, with me. If your Lordship permits me, I can read the synopsis of both the PIL, Lordship.
My lord, may I submit, my lord, on his paragraph, page 12, paragraph 4, I have categorically stated the earlier PIL. Page 12, paragraph 4. My learned pen is, my lord, trying to avoid the real issue. Page 12, paragraph 4, my lord. What is the sorry plight of these villagers, my lord? I have stated this PIL, my lord, is regarding misappropriation of fund filed by some of the public spirited citizens. That is the categorical stand. Now here the petitioners are the affected persons who have come for their own legal rights, my lord.
Heard, Mr.
B. Borua, my lord.
B. Baral and counsel for the petition. Issue notice. Who appears? Public Works Department? MS? M does, then it's Standing Council. Public Works Department appears for respondents. One only.
Seven. No, eight.
How about eight?
Eight, I will.
Oh, yeah.
And sales.
Uh, 1 and 8. 1 and 7. And Revenue Department, North Kachar Hills. Dima Hasso,
I will accept the note.
Mr.
I am.
RM Das, then Standing Council. Dima Hasso appears for the respondents. 2,
2 to 5
2 to 5,
and 8 and 9.
and 8 and 9. How about 10?
State.
And MS on what? When the government advocate appears for respondents. 10, 11, and 12. How about respondent 6?
6 is my lord.
Deputy Commissioner. My
Deputy.
learned friend will appear.
So here for 6. 12. Petitioner to take steps for service of notice on respond number 13 by registered post ID within 1 week from today. Stop. List after 4 weeks.
My lord, I have a prayer, my lord. Since the art cutting is going on, my lord, your lordship may kindly observe some interim order, my lord. I am praying that without due process of law, at least they should not do anything, my
No,
lord.
Lordship, that I am strictly.
So far,
objecting
our
to
land,
that
my lord.
interim prayer, Lord.
That let the respondent number 13 appear after that will.
Well, your lordship will fix it on 29. The other PIL is also there. My learned friend is referring.
29 will not be 4 weeks. We are sending it by registered post. So
So
we
your
have
lordship
to
will kindly observe the interim order will be considered.
pray for interim shall
On
be
the next
considered
date.
on the next return.
At least date may be given, my lord, because this contractor may not be a, my lord, a necessary party, but our rights, my lord, is of immense necessity.
The private respondent, they have implemented the contractor, Lordship. Let him also appear, Lordship.
List on 15th February.
15, oblige me.
Item 4. May I please, your lordship? Lordship, here the respondent may lordship sanctioned the credit amount of rupees 9,80,000 initially, lordship, on 28/1/2013, lordship.
Mm.
Thereafter said credit loan facility was enhanced 1,20,000 on 9/10/2013, lordship. Annexer, lordship, to page 21, lordship. Lordship, got it, lordship.
Mm.
Page 21, lordship. Initially 9,08,000 was sanctioned, lordship. Then purpose working capital, lordship. Here the petitioner, he is a registered contractor of MES, lordship. And thereafter, lordship, on annexer, next page 25, lordship, said loan was enhancement of 1,20,000. Total amount is 11 lakh, lordship. Page 25, lordship.
Mm.
The petitioner has paid the monthly interest in every month regularly, lordship, till 2021, lordship.
Which month?
Till 2021, 5/10/2021, lordship. On I have annexed the bank statement and category statement made in my paragraph, lordship. This paragraph 5, lordship. Page 8, lordship. Paragraph 5, lordship.
Yes.
Page 8, that in page 8, lordship. That in every year since 2013, lordship, In the year 2013, from the date of sanction, lordship petitioner paid 57,200. Thereafter, 2014 lordship 2,29,000. Thereafter, in the year 2015 lordship 1,73,200 lordship. 2016 lordship paid 2,43,000. Again, 2017 lordship 1,61,600 lordship. 2018 lordship 1,19,000. 2019 lordship 1,74,053 rupees lordship. 2020 lordship, during the time of COVID, petitioner also paid lordship 1,26,852 lordship. Then lordship 2021 lordship, due to loss of the business, petitioner paid only just 2,550 lordship. And the total deposited amount is 13,57,838 lordship. Out of the sanction credit loan lordship, 11 lakh lordship. So here the petition, the responding authorities just take their interest amount and the principal amount is the same lordship. It is still lordship. So on lordship, page they issue the implement notice lordship on 5/10/2021, page 44 lordship. And it's by page 44 lordship. Issued implement notice on 5/10 lordship. And here lordship, next page 45 lordship. They mentioned that limit sanction only 11 lakh lordship and the principal outstanding. Next page lordship, got it lordship. 45 lordship. Principal outstanding rupees 10,52,000. Amount in outstanding rupees 29,9/2020 10,74,491. Thereafter lordship, due to financial problem lordship and he is not also getting his payment due from the concerned department lordship. The petitioner is not able to pay the amount. So the petitioner regularly touch up with the respondent bank authorities. They're on lordship 38/2023 lordship, page 48/6. There is a settlement of the credit facility between the petitioner and the respondent bank authorities lordship. Page 48 lordship. Lordship, got it lordship. Yes, lordship, settlement of credit facilities availed by the NA Borbaya here petitioner lordship. So lordship, next come to the page 50 lordship, 49 lordship, 49 lordship, next page lordship. They have calculated the total amount lordship on 17,45,933 as an interest, compound interest on today that up to 38/2023 lordship. And thereafter they decrease it and next at the specific request, there are two lordship at the specific request of the borrower and as a special case of the bank accede to the request of the borrower and pay rupees 13 lakhs against the aforementioned acknowledgement liability of 17,45,933 lordship as on 31/7/2023 in full and final settlement of outstanding dues of the pension above towards all claims and dispute between the parties lordship. So the said amount 13 lakh lordship was divided in two part of payment lordship. Next page lordship, 6,50,000 and 6,50,000. But due to problem lordship, the petitioner is not able to pay the amount lordship. So the petitioner wrote a letter to the respondent authorities for enhancement sometime lordship, for giving some time so that he will pay lordship. He also wrote the letter, but they declined it lordship. So being agreed, the petitioner came before this honorable court lordship. Page 56 lordship, they have rejected the settlement amount lordship. Page 56 lordship. Through mail lordship. Yes, sir, this is to inform you that as you have not complied with the terms and conditions of the settlement letter, it's then cancelled lordship. After that lordship, petitioner wrote a representation, but they did not agree with lordship. So my humble submission before this lordship, they may issue the possession notice, they may give the possession notice or may acquisition of the petitioner land and building lordship. So notice may be issued and stay the order lordship.
What order?
This is lordship, they may,
They have not issued the position notices.
although they have not issued the possession notice,
Premature. This writ petition is premature.
so lordship, although they have not issued the.
You come after the position notice is issued. How can we pass an order not directing not the respondents not to pass any orders?
Sure.
Oh,
Or-
particularly
or-
when you have failed the settlement.
I'm praying before for another 6 month time to repay the settlement amount lordship. On this basis, lordship, I came before this honorable court. As I, in my annexure lordship,
You approach the bank for that.
representation page 58 lordship.
You approach the bank. This writ petition is premature. You
Ex-
come,
ex-
well, you come when you agree.
No, sir.
You withdraw it with liberty to file afresh. We'll give you that liberty. It's Mr. N.H. Laskar, correct?
Yes, Mr.
Then I counsel for petitioner, press for withdrawal of this writ petition with liberty to file afresh. Accordingly, the petition is dismissed on withdrawal with liberty as per.
Highly obliged.
Item 5.
May please your lordship.
Yes.
We have come against an order passed by the State Bank of India for taking physical possession of property under the SAFICI. Now, my lord, is a limited power has been given to the under 226 to exercise. So far as DRT matters are concerned. By judgments of the Supreme Court, latest judgment 2023, there is a judgment. Very limited power has been given. Unless there is violation of some principle of natural justice, certain provision from Whirlpool, starting from Whirlpool. I'll submit before lordship, it falls under that category. Not on the merit of the case. Merit of the case is any order passed under SAFICI, you have to go before DRT. That's the procedure which has been laid down. Because there is statutory, a provision is there. So whether you can exercise an alternative by way of moving before this in extraordinary under 226. Now, what was the case, my lord? Just in a nutshell, I'll say in 2 minutes, my lord. My lord, this is a company where they took a credit facilities from State Bank of India amounting to about 50 crores, which was given to this company. Now, against that, they mortgaged certain property. 13 properties were mortgaged. Now, this was enhanced after some time, period of time. From 50 crores, it went to 57 crores. It was a credit facilities was given. Now, after giving the credit facilities, my lord, 2020, the COVID came, COVID-19. So the business has slashed down, it has gone down. Now, there is a scheme which is given by the government of India to those small businessmen, is saying that whoever has suffered loss, so they will give a scheme was given by the government of India where they will get certain benefits, help. So this, the government, the bank has given on papers about 13.9 crores on sanction. But ultimately the sanction was only to the 5 crores they have given, rest they have not given. Now, the payment could not be made because of this pandemic. Now, it continued till 2022. Now, thereafter, my lord, they could not make the payment. And ultimately, they went before the OA, filing it before the Calcutta. They took the jurisdiction there. But the bank is here. Now, under 13.2, SAFICI proceedings simultaneously you can move. There is absolutely no bar in it. So 13.2 a notice is given. So when a notice is given under 13.2, it's a mandatory when under the SAFICI. So now I have given a reply. It's a reply has to be given. Now after the reply, they kept quiet. They did not give any information to our reply, whether accepted or whether rejected. That's a mandatory provision. Because after Mardia Chemicals, paragraph 45, your lordship will kindly look into it. These 13.3A provisions were not there in Mardia Chemicals. Only after a judgment of the Supreme Court in paragraph 45, that is spelled out that this is when a reply is given, it is a duty of the bank to give information to what about your reply, whether accepted or rejected. With reasons, that was not there. That's our whole case. So this thereafter, after the Mardia Chemical, legislature decided that to insert a provision, that is 13.3A, by virtue of the Act. Rules also prescribed, procedure has been laid down under what manner the bank should give a reply to our reply which is given to the bank. So that's procedure they have violated. So what our limited case, not touching the merit of the case, or whether, what is the reply? Suppose tomorrow they come up, State Bank of India, and they say, we have given a reply, then is the end of the matter. So limited, my lord, I think State Bank of India, I don't know whether nobody is there. We inquired. So we made Union of India as a party. So now kindly see, my lord. There's a 13.4, they cannot go it. They cannot go directly to 13.4. Taking physical position, you have to evil that 13.3 and give a reply to me. This is what, my lord, I have limited prayer is that the lordship will issue a notice and look into it. Kindly see first, my lord. Page 32, my lord, will kindly see, my lord. 32. This is a sanction credit facilities. Sanction of credit facilities at page 32.
Hmm.
Lordship got it, my lord.
Yes.
Kindly see 50.50 lakhs. Loan will disburse after obtaining second set of satisfaction. So kindly turn to next page. Next means page 51. This was enhanced sanction of credit facilities. See at page 51 in the column where it is 50.50, it is enhanced to 57. Please see on the left is 57. So now this is what, my lord, we have mortgaged about 13 properties against this to the bank. Now at page 79, once the COVID came, my lord, we could not, my lord, repay the amount. So there was a scheme by the government of India. That scheme was, my lord, we took the help of that scheme at page 79. Kindly see, my lord, sanction letter for guaranteed emergency credit line extension. We have the pleasure advising you sanctioning extension fair to augment net working capital, meet operating liabilities and restart operation. The limits are available subject to acceptance, fulfillment terms and conditions. So 13.94, kindly see the sanction which was given. Now, my lord, 13.94, they have given to us, but at page 82, we made a request. 5 crores we received, rest the amount we have not received. At page 82. This is a release for so and so. Messrs. Puja Tile, so and so. Kindly see the first paragraph. After the COVID-19 pandemic, the business at large has been impacted, resulting in low turnover and slow realization of debtors. To extend support of business enterprise, government has launched special scheme by providing 100% guarantee coverage to banks. Based on the same, we have applied so and so. That's the scheme, my lord. Accordingly, 1.0 extension of 13.94 crores was sanctioned to augment working capital, meet operational liability, and restart operation. We have several occasions requested disburse the limit of 19.94 crores. However, you have disbursed the limit of 5 crores till date had not paid it to our request of further disbursement. So requested so and for disbursement of those amount. Now this was request was made on 7/1. Thereafter at page 83. This is the last request earlier we made. This is the last request we made at page 83 on 9th of January 2023. Okay? Nothing has happened. They have not done anything. Then, my lord, at page 84, these are the, my lord, these are the mortgaged property, my lord, which we are given. So what we have given a proposal to the bank, my lord. The proposal was that you release this property. What we'll do it. 13 properties are there. 13 properties value will be much. Release some properties here. What we'll do it, we'll sell it. And whatever the amount, we'll put an escrow account. And in the escrow account, we'll put this amount. So you can take this. Ultimately, we are not getting this the amount from them. So this is a letter was made on 7/1/2023. Nothing has happened. 86, my lord. Again, we requested them. They have not given any hit to us. Page 88. This is a notice under 13.2. 13.2 notice. It is a mandatory under the provision. This is on 27/3/2023. Lordship, kindly see. This is a notice which was given under 13.2. If your lordship kindly turn to page 89, kindly see 7. If you fail to repay to the bank the aforesaid sum, so and so as on 26 with further interest and so and so, terms of so and so. And 11, notice is with a prejudice to the bank rights to initiate such an action or legal proceeding as it deemed necessary under any other applicable provision of law. So provision of law, recovery under the DRT Act, you can go ahead, or any other law is a surfacing. Simultaneously, it can be moved. Now we given reply at page 96. Page 96, we have given reply on 14/7/2023. This is the reply which was given on 14/7. See at page 97, at 3, that at the outset, we are hereby informed, though your notice under 13.2 and enforcement of so and so, the said notice has been received by my client only on 19/5. Hence, the said notice has not been duly served in time to my client, and the said notice has been deliberately held back to your official for your wastage, because there are certain time limit. Even then, my lord, whatever may the reason, we have given reply. See at 98, paragraph 8, that the said notice is bad and not maintainable, as details of the alleged liability contemplated 13 of the have not been provided. Statement of account in respect of said alleged NPA accounts has not been provided, which is mandatory before proceeding under the provision of the Securities Act. Said notice has not been accompanied by detailed statement of accounts, thereby preventing my client from asserting. So it is a mandatory. You have to provide the details, which was not done. Nevertheless, my lord, at page 101, the possession notice, 23/8/2023. It starts from 101 to 116, different properties in possession till 106, your lordship, 116, because your lordship has seen the list of the properties. These are the possession notice, starting from page 101 to 116. Your lordship will kindly note down. 116, then 117, there is a procedure, 117, which is entrusted to the subdivisional magistrate. Whenever possession, they give a notice before that, peaceful handover of the possession. So this is order of 12 October 2023. Details of the asset, and as request has been made to district magistrate on 12 October 2023. The circle officer so and so, in securing possession of secured assets provision of so and so, under rule, the order is made on request of the authorized officer, White, as affidavit so and so, so and so. Now, my lord, your lordship got it, 117. Now, this is what we are aggrieved. At page 119, 119 is 4/12/2023. A request for peaceful handover of mortgage properties under 13.2. So this is what they make a request to hand over on 4/12/2023. Now, normally in SARFAESI, there's a symbolic, thereafter the possession, physical possession, they come up for taking physical possession, which you also will find at page 121. That is 27th of December 2023. Physical possession of the property. What you will kindly note down. With reference to, I would like to inform you the date for physical property under so and so. You are requested to take, this is fixed on 20th of January 2000. Kindly note the date, my lord. 20th of January 2022. Now we are before this honorable court. Only on the legal issue, my lord, only what I am asking, my lord, a limited protection, because lordship will now see the provision which under 13.3, see the SARFAESI Act. I book from this, huh? See, kindly see the SARFAESI.
Yes.
See the SARFAESI, my lord, Act. See at section 13, lordship got it. This is enforcement security. This is 13.2. I don't want to just, 13.2 is a notice is given to the borrower, a guarantor. This is the amount which is due. You have to repay it. Now 13.3, kindly see 13.2 is a notice 13.3, notice referred to in subsection 2 shall give details of the amount payable by the borrower and secured asset intent to be enforced by secured creditor. So details of the account can be noted down. This is what they have. No, these are all draconian law. The SURFACE, PMLA, all the procedure has to be followed. This very draconian type of law. So that's why it's provided details of account which we have written to them. Now see 3A, which was not there. 3A came only after the judgment of Mardia Chemicals. That Mardia Chemical judgment, your lordship, is this is 2004 Mardia Chemicals 2004. After that, your lordship, you see the bottom, it's only came on 11/11/2004 after the judgment of Mardia Chemicals. Now this 13.3A was inserted. If on receipt of the notice under subsection 2, the borrower makes any representation or raised any objection which I have showed, the secured creditor shall consider such representation or objection, and if the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such representation or objection, reasons for not acceptance of the representation or objection to the borrower, provided that the reasons are likely so and so, at this stage shall not confer any right so and so, so and so. So these are, my lord, procedure which has been laid down. These are all, you have to follow it. Now kindly see the rule. Kindly see the rule at Rule 3A. That is Security Interest Enforcement Rule 2002. Rule 33A. 3A, my lord. The reply, lordship has got it. 3A. 3A Security Interest Enforcement Rule 2002. Kindly see 3A. Reply to representation of borrower. After issue of demand notice under subsection 2 of section 30, if the borrower makes any representation or raises any objection notice, authorized officers shall consider such representation objection, examine whether the same is acceptable or tenable. Now kindly see C. If on examine representation made an objection raised, authorized officer come to the conclusion such representation objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such representation objection, reasons for non-acceptance of representation objection to the borrower. I found one judgment of this court also after the Mardia Chemicals that they said that yes, these are mandatory provisions. Otherwise, your lordship generally doesn't exercise. Your lordship's power under 220 exclusively power, unless there may be violation of principle of reason, then only your lordship steps into it. These are the ambit of the DRT to decide. So on limited play, your lordship will issue a notice, and in the meantime, let them come up State Bank of India, my lord, and let them say before the court that they have complied. Then your lordship will take a call on it.
Right, Mr. Didas. Leonard Senior Counsel, assisted by Mr. R. Sharma, Leonard Counsel for the petitioner. Who are the respondents?
Respondent will
Issue
be,
notice.
yes,
Union of India,
yes.
I'm appearing for respondent number 1 and 2 on behalf of Mr. S.K. Mehdi, CGC.
Mr.
S.K. Mehdi, I'm K.K. Mehdi.
K.K. Medil, Leonard Counsel, appearing on behalf of S.K. Medil, Leonard CGC, appears for respondents 1 and 2. Assam Commission Secretary,
Commissioner Secretary Department has not been through.
yes. Which department is this?
Three departments, sir.
Any respondent.
Finance Department. Yeah. Department of Finance. I will just correct it, my.
You can't correct it. You'll
I-
have to file in IA.
I will file it. There is no problem. We'll file it. He can receive it. We'll file it now in the meantime.
Minutes. Separate study council is there taken.
We will serve it. We'll make it and we'll serve it.
Mr. Endas, Leonard
4, 5, 6,
Additional Senior Government Advocate, appears for respondents 4, 5,
6.
6. 4, 5, and 6.
789 is the main.
Petitioner to take steps for service of notice on respondent 789 by registered post.
Yes.
AD within 1 week,
Yes.
within 1 week from today. List the matter after 4 weeks. Yes,
Senior
interim, you want?
Yes, yes, I have prayed for interim. The effect of this notice 121, that should not be given effect to my 21 2000. I have come before that, my. At page 121.
Into interim.
Senior.
No, but where is that position notice?
Yes, this is what I have come. They want to take position and fix on 21 2024.
The
This is a type copy.
communication. Dated 27/12/2023. Written by the Circle Officer, North Guwahati Revenue Circle, Amingaon. And addressed to the authorized officer SBI. Stressed Assets Management Branch Dash Raman 2. Shall remain suspended.
Yes,
Internet.
I'm deeply of it.
Take notice for the final.
Okay. And MS
Dr. P. Barwa,
P. Barar,
on behalf of Mr. B. Gogol, Lordship, I'll take.
council appearing on behalf of Mr. B. Google
Respondent 3.
appears for the
Respondent 3.
B.
Respondent with
Google and the
Lordship.
Standing Council Finance appears for respond number 3. You file an IA for correction.
Oblet.
Item 1.
Where is your Lordship? Lordship, Mr. T.J. Mohanto, Senior Counsel, he is on Lakeshore Court number 17, Lordship.
Who?
T.J. Mohanto, Lordship. In Pion, after some time, Lordship.
Item 6 for admission.
Yes, Lordship, the issue I have raised by the way of filing this PIL is that ignoring public opinion and violating the excise rule, the excise department has taken the initiative to issue license for the IMFL on show, that is a liquor show. But so the background of this PIL is that they are going to
Right.
issue license.
My lord, first and second inquiry has been done, and after that, third inquiry has been also conducted. But it is found that all these inquiries has been conducted in accordance with the Assam Excise Rule 289, 294, and 295(3). They have already complied with.
Have you filed an affidavit? to that
Lordship, I have filed first affidavit. Thereafter, while they have put some questions about DUG numbers, thereafter I have filed this second affidavit also. It is there.
Lordship, I'll submit thereafter. My learned friend may complete first. I'll submit.
So what do you want today?
Kindly dispose it.
You want a disposal today?
Yes. Inquiries has been conducted in accordance with all the rules.
Okay. Then we'll list it after the Bihu.
Lordship.
Not
Kindly,
today.
kindly sort that. And we keep it.
Okay.
Already they have.
List this matter for final hearing. Okay. List this matter again on 29th.
Right, Lordship.
20.
And Lordship,
But after that, Mazumdar, then the counsel for the petitioner. As well as MS,
MSP, case Sekia, for
Yes.
this Sekia.
case High for the
I'm appearing for the excise department as a
The-
standing counsel.
another standing counsel for the excise department. And Mr.
D. Chaudhary Malak for the respondent number 6. Private.
P. Jautri, legal counsel for 6. List the matter on 26th, 29th.
Detail.
Yes, person.
Item 1.
Keep this in item 6. Yes.
Lordship, this is a PIL addressing the issue of witnesses becoming hostile in ever increasing numbers. So in the case of Mahendra Chawla, the Supreme Court of India has given us the Witness Protection Scheme 2018. And regarding its implementation, I have made an RTI where I have asked various information about its implementation in Assam, where one peculiar fact came to the surface that hardly anyone has applied for protection under the Witness Protection Scheme. So there is only one conclusion one can arrive, that people are not aware about the existence of such a scheme. They don't even know that the court has made a facility for providing various kinds of protection to the witnesses, but hardly anyone has asked for protection under such a scheme. So here through this PIL, I've made certain prayers asking for the High Court, for instance, to provide information regarding this scheme in their official website, and the police also in their respective websites, they will publish information about the witness protection scheme. And also another aspect of this PIL is that in this case of Mahendra Chawla, the Supreme Court has directed that there should be some special courts to be made under this scheme. And these special courts, if you look at, Lordship, do you need the case?
No, not equal.
Okay.
Yes.
In the sub,
My lord, yeah, issue is good, very good.
Yeah.
There is a scheme, my lord, it is scheme was, my lord, adopted by the Honorable Apex Court in, my lord, 2019-14 SCC. That has to be implemented in the other state also. There is a para 26, my lord, clearly 28, clearly mentioned. So in state, my lord, it is yet to be, my lord, adopted, or my lord, till any act made by the legislature, my lord, that 141 and 142 of the Constitution, my lord, is binding. So, my lord, now, my lord, here in this case, my lord, that state has to, my lord, that government of Assam has to take an initiative, my lord. So state, my lord, here in this case, my lord, the chief secretary or any government, my lord, home department is not a made party. So may I pay that if the chief secretary or home department made party, then it will be, my lord, easier. Because otherwise,
Oh.
registry will, my lord, we
Oh.
cannot do.
No.
Registry cannot frame the issue.
no, I'm asking the registry at least can, if you.
No, we want to
Here.
see whether the scheme has been adopted by the government.
No, I'm not saying that. I'm saying that the High Court should take some proactive steps so that the people become aware of this.
But
So the registry.
whatever it is, at least you should implement the state government.
My lord, in respect of the High Court, there is a guidelines, my lord. Notification is there, my lord.
Mm.
That is, my lord, I am responsible to my planet, and he also, my lord.
So if you
Second
come,
of,
Lordship,
23rd,
if you come to the prayer number 1, the respondent
Yes.
number 1, that is the registry, to organize public awareness workshops regarding the witness protection scheme in the various district courts subordinate to the Guwahati High Court.
Mm. Mm.
scheme to some very good money. There is a guideline for the Supreme Court. High Court, our guidelines আছে তো?
Implement করা যায়।
Yes, correct.
And regarding this new Bharatiya Nagarik Suraksha Sanhita, that is yet to be
That is,
notified.
petitioner,
Yeah.
why don't you implement the state government and come back?
High Court tell you.
Okay. If that is a necessity, then I will do so, Lordship.
You want to file an amended course title, or you want to file an IA for amendment of the course title, or you want to withdraw and file afresh? It's
No,
up to
I
you.
will find an amendment petition.
Okay. Mr. The petition in person prays for
The number three.
how much time?
2 weeks.
2 weeks time for filing an IA for amendment of the cost title. Praise the Lord. Please.
Much obliged.
Declare.
Item 7.
May it be the Lordship. Lordship, I pray that the matter be taken up after some time, Lordship. Lordship, the learned advocation is appearing in some other court, Lordship. After some time.
Item 8.
Your Lordship. Lordship, in this matter, I pray for some accommodation. The matter of the petitioner hearing is pending before the FAO. Thereafter, it will be done. A short date may be given, Your Lordship.
Oh.
FAO.
All right, they admitted, my lord, because of their
Yes.
communication I have received, my lord. They
Yes.
said that because of the non-receipt of the fund from the government,
Yes.
that it is not been paid.
Mr. T.J. Mahanda, the senior counsel, assisted by Mr.
V. Raman.
V. Raman, the counsel for the petition. On request made by MS
And Bordeloi.
N. Bordele and the standing
The-
counsel, Revenue Department. When do you want?
Lordship, out on 23rd or 25th, Your Lord.
Let it be in the month of February, my lord, because that period, my lord, most of the items
Yes,
were
Your
fixed, my lord.
Lordship. On the safe side, it's
And also 26.
7 February.
My lord,
7th of February.
declare.
For response number 1, 3 and 4, I
D. Nath, the senior governor advocate, appears for respondents. 1,
1, 3, 4 and 5.
3, 4, and
Declare.
No pledge.
Item 10.
May I please, my lord? My lord, we have challenged the order passed by the learned single judge. My lord, the facts of the case in brief is that, my lord, a writ petition was prepared by the respondents herein, my lord, who are 153 numbers. My lord, they have claimed for the compensation for the lands which were used by the railway. My lord, railway has acquired a certain area of land, my lord, on a temporary basis. My lord, for the construction of the service road. My lord, a railway project was initiated, my lord, in the year 2004. My lord, in that process, my lord, for the construction of the approach road, railway has acquired, my lord, certain land on temporary basis, my lord. There was no permanent acquisition of land. And my lord, at that point of time, around 53 numbers of owners were there, my lord, who were the patta holders. So, my lord, the railway has executed a lease agreement with them. And my lord, they were granted the compensation on the basis of the lease charges, which the railway, my lord, normally gives as per the policy. My lord, then after, my lord, 12 years, my lord, another set of writ petitioners came. And my lord, these were the petitioners were 153 numbers. And my lord, they claimed that they should also be paid those lease charges. My lord, the contention of the railways before the under single judge was that, my lord, the land on which the petitioners were staying, my lord, those were the railway government land, my lord. And for the government land, my lord, the railway need not pay compensation, my lord, except, my lord, any value of Ziraat compensation if they are entitled to. So, my lord, the judgment, my lord, the relevant portion starts from page 67, if I may read, my lord. Page 67, my lord, put it paragraph 4 onwards. My lord has got it.
yes.
Page 67, my lord, paragraph 4. A stand is taken by the railway authorities that the land of the petitioner is a government land. In that respect, we take note of a communication dated 26/2/2016 from the Deputy Commissioner Dhemaji to the Deputy Chief Engineer Bogibeel Bridge Project, Silapathar Dhemaji, providing that certain land has been used for construction of service road from Kulazan to Karinghat Bogibeel project, but in respect thereof, compensation has been paid to 53 affected landowners, but another 148 landowners have been excluded from the benefit of payment of such compensation. Accordingly, the Deputy Commissioner estimated an amount of rupees 9,93,620 for annual patta lands that have been utilized by the railway authorities, and another amount of rupees 2,36,79,300 in respect of 219 bighas, 4 kattas, 16 lichas, which apparently appears to be government land under occupation of the respective landowners. Accordingly, a request was made that the aforesaid amount be released at the earliest. The railway authorities, in response thereof by the communication dated 29/16 from Yashpal Singh, Deputy Chief Engineer, NF Railway, Silapathar, had informed the Deputy Commissioner that the land was taken on temporary lease for the service road from Kulazan to Bogibeel, but in respect of such temporary leasing, the railways can give compensation either to individual patta landholders or to the government for government land. My lord, this is important, my lord. If it is the stand of the railway authorities that in respect of the government land or occupation of the respective landowners, the railway authorities will pay the compensation only to the government and not to the landowners, be it so, but let the appropriate compensation be deposited to the government through the Deputy Commissioner Dhemaji. My lord, it is this part which we are agreed by, my lord, because in case of a government land, my lord, the railway which has acquired the land on a temporary basis, my lord, what can only be paid is not the compensation, acquisition compensation, my lord, what can be paid is the lease charges, that to the government, my lord, but thereafter, my lord, page 69, in paragraph 7, my lord, the seventh line, my lord, it starts from further.
Yes.
Further, if the deputy commissioner, upon examining the entire records, find more number of landowners who were deprived of compensation, deputy commissioner may accordingly inquire and assess the matter and do any further acts as may be required under the law. Upon compensation amount being deposited by the railway authorities, the deputy commissioner Dhemaji may disburse the same as per the appropriate apportionment to respective landowners as they may be entitled under the law. So, my lord, our basic contention is that, my lord, for
What is this in para 7, the first line?
accordingly as agreed upon, yes, my lord, accordingly as agreed upon by the concerned official.
It was a consensus order then.
It was a consent order, my lord, but the direction was given to examine the matter afresh, and which was, my lord, in fact done. My learned, the other side, my lord, they have filed the additional affidavit wherein what the affidavit in opposition filed by the other side, if my lord may take page 185, annexure B.
What affidavit in opposition?
My lord, they have brought into, my lord, they have brought subsequent, my lord, after the passing of the honorable court's order, my lord, a fresh verification was carried out in terms of the court's order, my lord, at page 185. My lord, annexure B. If I may read, my lord, there is an observation by the deputy commissioner that the 128 numbers of effective families, my lord, they are occupying the government land. And my lord, the acquisition of the land was on a temporary basis and lease agreement was executed between the parties. My lord, so far as the patta holders are concerned, my lord, railway has no objection to that, my lord. We pay compensation to the owners of the land. But my lord, to those owners, my lord, who are occupying the government land, the railway is not entitled to pay compensation, my lord, except the lease charges, which is, my lord, to be which are to be paid. My lord, I am just pointing out, my lord, to this annexure B, page 185. If I may read, my lord. This office has submitted a list of 128 families occupying government land and 28 families in possession of private land. After field verification conducted in pursuance of the Honorable Court's order and in response to your office letter dated 21/11/2022, the submitted list is prepared based on the circle officer's report after joint verification in presence of officials of land, revenue officials and affected persons. It was made clear in paragraph 3 of the letter dated 17/5/2023 that no ownership documents are available for the affected families occupying government land. For the 28 families possessing private lands, documents were submitted along with this office letter dated 27/23, and the copies of same are resubmitted again in the enclosure of this letter. It is pertinent to mention here that your contention in paragraph 1 and 2 of your letter dated has unfortunately missed to take into account the direction in para 5 of the Honorable Court's order. Although the railways have been repeatedly insisting upon the ownership documents, it was made clear several times by this office that the proposal of compensation is prepared in pursuance to the Honorable High Court's order, which was clearly directed to deposit the amount of compensation against the government land also. So this is what we are, my lord, basically agreed by. Therefore, the question of ownership does not arise. And my lord, in the last paragraph, my lord, the deputy commissioner, my lord, gives a finding that however, if any review is desired by the railway authorities, you are requested to raise the specific objection against specific parcel of the land or affected person so that this office can effectively look into if any revision is necessary. My lord, our basic contention is that, my lord, the amount which is calculated subsequent to the order passed by the honorable court, my lord, that cannot be land, my lord, compensation. That can be only lease charges. And for the owners cannot be given, my lord, the landowners who are occupying the government land, my lord, they cannot be paid the compensation, my lord.
The only hurdle is that it was a consent order.
My lord, it was a consent order, my lord, but
If you have some problem, you can file a review. That will be better.
my lord, so far as the observation, my lord, which is regarding 28 families, my lord, who are in possession of private land, my lord, they have produced the ownership documents.
See, if you have a grievance against the deputy commissioner's letter,
My lord,
you have you have alternative remedy. You can raise this in the writ appeal.
my lord.
Number one. Number two, the judgment of the learned single judge was a consent order, consensus order. So if you have a problem, we can file a review before the appropriate court.
My lord.
That will be better.
My lord, we are only agreed by the, my lord, that part, my lord, which I have read at page
No, but
6.
then the problem is that it was a consent order. Already it is clearly stated in paragraph 7.
My lord,
So now beyond that, what can you do? All you can do is go and agitate before the learned,
my lord.
before the court saying that no, it is not a consent, it was not a consent order so far as this part is concerned.
My lord.
That after that you can come if the review is not allowed.
My lord, we give that liberty in that case, my lord, we'll make an observation.
Mr. Ash Gupta, Learned Counsel.
My lord, otherwise also, my lord, the railway is the beneficiary of the acquisition of land, my lord. Railway has no right to, my lord, to challenge the, who is, and as per section 10, my lord, all land after acquiring from the private personnel becomes a government land, my lord. The government has the power to, my lord, to allot the land.
So he is withdrawing this, so we'll give Ash Gupta, Learned CGC.
My lord.
Appealing for the applicant's price for withdrawal of this writ appeal with liberty to file a review application. Stop prayers allowed. Writ appeal is dismissed on withdrawal with liberty as spread for.
Like,
Item 11.
Here, in terms of lordship's order, my lord, we filed the application for amendment, my lord. That is, I think, not in the record.
Amendment application.
Yes. For amendment of prayer, my lord, there was mistake in my earlier writ appeal prayer, my lord.
1 minute.
I am not listed, my lord. Not listed. After Bihu vacation, my
You filed it, isn't it?
My lord, yes, we filed.
Mr. R.P. Sharma, the senior counsel for the appellant submits that the appellant has filed an IA
Yes.
for amendment of the prayer portion in the present appeal. Stop. Registry to verify and place the same on report.
Filing number is, my lord.
Registry to verify and list this matter.
My lord, filing number is
No,
equal for.
that's fine. With the IA on, when do you want?
24th, my lord.
24, there are too many cases.
25, 26, my lord.
Maybe first or 2nd February.
Yeah, yes, sir.
2nd February.
Highly obliged.
My lord, interim order may continue.
What interim is there?
Status quo is there.
Status quo is there, my lord, that it may not be continued. Because status quo is already there,
That is there already. That
not
means-
required to continue, my lord. I think.
holding the post.
Yes, I am holding the post.
Is-
Holding the.
Yeah,
Already
interim
status quo is
order
there.
possibly to continue. The next six.
Obliged.
Yeah.
Item 12 for orders.
Interim order may continue, my lord. Obliged.
This initially the PL was closed. This is with regard to an incident that has happened in Potadrova. The house of the accused was demolished by using bulldozer by the government. They have filed an affidavit wherein Miller they have admitted that there were serious flaw because no permission was taken, nothing. Thereafter, the PIL was closed at the assurance of the government that a committee will be formed and appropriate decision and action will be taken. Thereafter, Miller, nothing
Have you
was
got the
done.
inquiry report?
Yes, yes, my lord, the inquiry report is not there, but I got the instruction that the one-man inquiry committee has submitted its report on 4th of January.
Where is the report?
Well, report is not with me, Milan. Well, kindly see the letter, Milan. The report was submitted on 4th of January 2024. The one-man inquiry committee headed by Sri Avinash Purushottam Das Joshi, IAS Additional Chief Secretary to the Government of Assam, entrusted to inquire into the demolition of house and custodial death of Safiqul Islam. And the Botodroba Police Station has submitted the inquiry report to the government in the Home and Political Department on 4/1/2024. However, it will take some time to examine the report stated above at the government level. So accordingly, they have instructed to take for 4 weeks time. But you may give us 4 weeks time, let the report be examined and the up-to-date status will inform the court.
At HK Das, Learned Counsel, Standing Counsel, Guwahati High Court. Mr. D. Nath, Learned Senior Governor Advocate, has produced a communication dated 10 January 2024, written by the Joint Secretary to the Government of Assam, wherein it is stated that the one-man inquiry committee had submitted the inquiry report to the government in the Home and Political Department on 4/1/2024. So, it further states that it will take some time to examine the report and therefore place for 4 weeks' time to file an affidavit.
I'll get the up-to-date status from the government. I'll apply.
Stop.
It is better to file an-
Learned Senior Counsel therefore place for 4 weeks' time to file an updated status
Lot.
report. Stop. Praise a lot. List. You want a date?
Date may be fixed.
Give a date after 4 weeks.
16th of February.
16.
The
Fine.
communication dated 12 December 2023. No, 10th,
10th
isn't
of
it? 10 January 2024 is placed on record.
Highly obliged.
Item 13.
May it please have your lordship.
Hmm.
Because in this matter, there's a caveat lodged by my learned friend that may be discharged.
Where's the caveat? Heard, Mr.
HK Burrow, my lord.
HK Borough, Learned Counsel, for the caveat. Caveats discharge. Yes, what is
Now,
the
my lord,
IA?
before your lordship, there's a writ appeal accompanied by an IA.
IA is for?
Leave for appeal, my lord. The present applicant was not made a party to the writ petition, and therefore an application has been filed so that leave may be granted and the appeal may be registered. Now, the matter, my lords, the matter pertains to a tender, my lords, a settlement of a mahal, my lord. So what had happened, my lords? The respondent number 1 writ petitioner, along with the present applicant and other contractors, my lord, they had all tendered for a tender pertaining to a mining concession area, my lord. And thereafter, my lord, the tender, as per the tender, it's a 2-bid system, my lord. The first is the technical qualification, thereafter the price bids. Now, the auction notice was issued on 26/10/2023, and thereafter on 16/11/23, the technical bids were conducted, my lord.
Oh.
In the technical bids, there were 5 number of contractors, my lord.
Hmm.
And pursuant to the technical bid, it is the narration of the writ petitioner that she was not informed of the results of the tender of the technical bid. Therefore, my lords, she filed an RTI application, and pursuant to the RTI application, my lords, the reason for rejection was given, my lord. That, my lords, would directly take up my appeal for a moment, my lord. Page 46 is the reason for the rejection of her technical bid. Page 46. My lord has it, no? Page
Yeah.
46. It says the digital signature,
Where?
page 46 of the writ appeal, my lord, the memo of appeal.
Hmm.
My lord, page 46, the memo of appeal, my lord.
Column?
My lord, the second last column,
Hmm.
the second row in the digital signature.
Hmm.
May I read, my lord? In the digital signature, Nilima Boro signed as Nilima Boro Kalita, whereas she signed in the name of the bid documents as Nilima Boro. Further, in her PAN Aadhaar card, her name is Nilima Kalita. In this regard, she has not submitted any affidavit regarding her name. So essentially, my lords, when she submitted her bid, it was in the name of Nilima Boro. But when the bid documents were digitally signed, it was signed as Nilima Boro Kolita. And therefore, the authorities had rejected her technical bid. Now, thereafter, my lords, after the rejection, the financial bids, my lord, financial bids were conducted on 1/12/2023. In the financial bid, my lords, there were 2 successful bidders, and the present applicant, the appellant, was the highest bidder. Now, after I was declared as the highest bidder, on the same day itself, my lords, a letter was sent by the DFO to the CCF conveying that I am the highest bidder and I should be settled with the tender. Thereafter, again on 4th of December 2023, there's another letter to the PCCF, who's the head of the forest department, that I'm the successful bidder and I should be awarded the tender. Now, what had happened on 4th, my lord, when everything was settled, the entire tender was completed. Tender 4th, the present respondent number 1 writ petitioner, she preferred a writ petition. She preferred a writ petition, praying for 3 reliefs, my lord. First, to accept the affidavit filed by her, which was belated. After everything was over, she filed an affidavit that these 2 persons are the same person. Second, to defer or postpone the financial bid, which was already conducted by the time she filed the writ petition. And third, to set aside and quash the tender. Now, the matter was first listed on 6th, pursuant to filing on 4th. On 6th, there was an interim order by this court, which said that if financial bids are not open, then it should not be open. But by that time, my lords, it was already open. First, it was already open. Now, the impugned judgment, my lords, which my lords would find in page number, starts from page number 50. I'll read out the relevant paragraphs, my lord. Page 50, the impugned. My lords may directly come to page 52, paragraph 6. Very short judgment, my lord. I'll read it. Page 52, lordship has it, my lord. It transpires that the discrepancy for which technical bids of the petitioner has been sought to be rejected, as would be discernible from the observations made in the comparative statement, is as follows. That's what I read before, my lords. Shri Goswami, learned counsel for the petitioner, however, submits that the surname of the petitioner was Boro, and she being married to one Binoy Kalita, there was some change in the surname of the petitioner, and therefore there is no substantial change in her personality, whether she signs as Nilima Boro or Nilima Kalita or Nilima Kalita. My lords, that is totally, my lords, in my humble submission. Person is known by the name. Thereafter, my lords, paragraph 8. This court, wide order dated so-and-so, had directed the learned standing council to obtain instructions and accordingly fix the matter for consideration today. It was further observed that the financial bids should not be open or the financial auction should not be held till the next date fixed, if not already done. Shri Pathak, the learned counsel, has fairly conceded that the ground of rejection appears to be trivial in nature. Now, I'll come to that later, my lord, whether it is trivial, whether it's an essential condition of contract or it's a collateral condition, my lord. However, he has submitted that financial bids were open along with technical bids on 17/11, and the same was followed by an e-auction held on 1/12/2023, wherein one bidder has been identified. He has further produced a copy of the communication dated 4/12/2023 issued by the additional CCF, PCCF, so-and-so towards issuance of work. This court is of the opinion that though there appears that there may be some discrepancy in the surname of the petitioner in the digital signature, in view that her identity and credentials are not in doubt, and she was earlier the settlement holder for a period of 7 years, the same Mahal, which was admittedly without any blemish, rejection of her bid on technical grounds of the aforesaid nature does not appear to be justified, as such discrepancy appears to be trivial in nature. Now, my lords, the tendering authority is the best authority to take a decision in that matter. By exercising judicial review under 226, this, in my humble submission, ought not to have been done. I'll come to the reason why, my lords. In view of the same, the writ petition is allowed by holding the decision of the department to reject the bid of the petitioner on technical grounds as unsustainable in law, and consequently all further action, including the communication dated so-and-so, issued by the additional CCF to the PCCF so-and-so issuance of work order are set aside. It is accordingly directed that the e-auction be redone and the petitioner be allowed to participate, and the price bid of the petitioner be considered. The aforesaid direction would also be in sync with the requirement of public interest, as there would be possibility of fetching more revenue in fresh e-auction, which has been directed to be done, since the issue involves settlement of a mahal where revenue of the state is concerned. The aforesaid exercise may be carried out expeditiously. Now, my lords, first, my lords, there was a direction allowing the petition of the writ petitioner. Thereafter, the Honorable Single Judge goes one step further and directs retendering of the entire process. Now, my lord would know, my lords, retendering involves a substantial expenses of the employer, my lords, and that goes from the public exchequer. Now, again, from the stage of publication of notice in the newspaper, thereafter conducting e-auction, then financial bids, my lords. Now, my lords, my grounds for assailing the impugned judgment is first, my lords, whether, my lords,
The
whether,
first issue is, without going into the thing, whether the leave should be granted to you or not, isn't
my
it?
lords,
Yeah, do you have any objections?
My lord, to the leave application, I'm not objecting to the leave application. So if he's granted leave, I have no objection.
now, my lords, in the meantime, what, as per my information, my lords, no steps have been taken as on date to retender, my lords.
We can't pass any order. Writ appeal is not yet registered.
My lords, in the IA, there can be orders passed, my lords. In the,
No. IA is only for.
So, my lords, he does not object to the, my lords, the IA. Lordship may
the
dispose
leave
of the IA, and in
application
the appeal, lordship would, because my matter would become infructuous, my lord. And there are strong grounds, my lord. The first ground, in my humble submission, my lord, whether the learned single judge was justified at all to exercise the powers of judicial review in a matter such as this. There's no allegation of arbitrary, malafide, nothing, my lords. What the Honorable Single Judge did, he went to check the soundness of the matter, my lords, not the legality. And as per the tender notice itself, if there are mismatch in signatures, it would lead to cancellation of the rejection of the bid. That was never considered, my lords. Might you kindly take up for a moment the tender conditions, page 87 for a moment, kindly, my lord. My lords, there are essential conditions and there are collateral conditions, my lord. If it's a collateral condition, the department or the tendering authority has the power to waive it off. But the court cannot do it. Now, in the instant case, it is not a collateral condition. It's a essential condition that would appear from page 87. Why is it an essential, my lord? As per G.J. Fernandez, if it entails rejection, non-compliance of a condition, if it entails rejection, is an essential condition, my lord. Page 88.9. Roman 9, my lords, page 88. My lords, have it, my lord? All scanned documents must be self-attached and combined into a single PDF bid document with page number, and Lordship would take note, digital signatures to be applied at the top of each page, to be mentioned in footer of the bid document in the following format: so and so, so and so, so and so is the total number of pages included in the bid doc. Otherwise, it will lead to technical disqualification. Now the authority, the tendering authority, was right in rejecting the bid, my lords. That was never considered. And I have a right, my lords. I'm the highest bidder. After a valid process of bidding, I have been. So what I pray as of now, my lords, let them file affidavit, my lords. In the meantime, Lordship may pass a order for maintaining status quo, my lords. That is the only
So
prayer,
what affidavit?
my lords.
What affidavit?
Lordship would fix it for admission. Till then, my lords, some protection, an order of status quo, my lords. It's an essential condition. It was never considered. And whether it is trivial or not, that with the deepest respect, my lords, the and a concession made by a council would not change the nature of the contract. Contract is clear, my lord. You put wrong signatures, you have to be careful. Shrewd businessmen, my lord, every one of them.
Where's your IA?
My lords. 123 of 2024.
You were not made a party in the writ.
No, I was not made a party. I ought to have been made a party, but I was not made a party.
But Mr.
T. Mahanta, my lord.
P. Mahanda, learned counsel for the petitioner, for the applicant. Also heard Mr.
HK Borrow.
H.K.
Borrow.
Barra, learned counsel, appearing for the opposite party number
One, my lord.
one. State,
All forest, my lord.
Forest, MS, M. Kalita, and standing counsel, appearing on behalf of P.N. Goswami, learned standing counsel, Forest Department, appears on behalf of the opposite parties.
3, 4, 5, 7, and 8.
2 to 8, correct?
Except 6.
6, I'll take steps, my lord. This is the tender committee, I'll take steps.
Okay, appears for the respondents 2, 3, 4, 5, 7, and 8. Stop. Then we'll have to issue notice.
My lord, would till then, my lord, status quo, only that prayer, my lord.
Issue notice.
Till the next.
Applicant to take steps for service of notice on respond number 6 by registered post AD within 1 week.
1 week. But till then, my lord, an order of status quo, my lord. Till the
Release
next
the
day.
matter after 4 weeks. Till the next returnable date, parties are directed to maintain status quo as on today.
I'm very grateful, my lord. It clears very much. My lord, the IA is disposed of, my lord. There's no objection.
I'm issuing notice on the IA.
Oh, fine. He was appearing for the IA.
He was appearing for the capital, but then you wanted to take steps on respondent 6.
My lord, I'll do that. Be clear.
What was I was thinking of disposing? Anyway.
Item 2.
There was nobody in the morning or? None appears for petitioner. List after 1 week.
Item 7.
Here, Malad, I am led by the learned AG, Malad. But Lordship, may kindly, since there are no more matter, Malad, kindly take it up on 19th of June.
This bench may not be there. Bench 1 may not be there.
It's a bench one matter.
No, that's why.
It's otherwise not part of.
We can list it after 20 seconds.
My lord, only problem is that I have no objection regarding their taking
No,
time. Last occasion also
in
they took
fact-
time. my lord.
In fact, we are
But the
ready, Malad.
contempt- In our submission,
Yeah,
this
petition.
contempt petition is not maintainable
That
because
was-
no punishment has been
No,
imposed.
on the
Now, on the ground of pendency of this contempt appeal, the original contempt case is being deferred.
Malad, on the maintainability point, we are ready, Malad. Kindly accommodate for some time, Malad. If Lordship gives us some time, Malad, because he got engaged in the other court, Malad.
Okay, on request made of on behalf of Mr. D. Saikia, Learned Advocate General Assam. List on
On 19th, if possible, Malad.
19th, I've told you.
Not,
bench
not,
one.
not. Okay,
24th. 24th.
Not.
Pendency of this contempt appeal may not be a bar for the my lord.
All-
Problem.
Please, your lordship, item number 2, I'm sorry, lordship, I was another place. May I, lordship? Item number 2.
Therefore, it is passed.
Lordship, kindly, this matter is a small issue, lordship. Issue is big, but lordship can pass the order accordingly.
Who appears on the other side?
On the other side, GA Assam, lordship.
Yes, I'm here, Lordship.
Misappropriation of
Yes, lordship, government fund, lordship, under the urban water supply sewerage board, lordship, under the Jorhat division, lordship.
will have to issue notice.
Lordship may issue notice or lordship may dispose with the direction to take necessary action on.
Then we'll record your name I think this is 2.
Item
MSM Nirulan Learned Counsel. It's the matter.
2 weeks, after 2 weeks.
You want it after 2 weeks.
Yes, sir.
Okay. Then you say cancel it on request made by MSM Nirulan.
Obliged, sir.